Hey again, everyone. Over the last couple of modules, we've been discussing a couple of the core branches of the federal government in the United States. And in this module, it's time to turn our attention to the third and final of those sort of three main pillars of government, that is the Supreme Court. Today, I want to talk to you a little bit about the process through which a case becomes a Supreme Court case. And certainly, I know many of you are probably thinking about this, given that the Supreme Court is in the news so much, especially due to the fact that, as of recent times, we're dealing with this question of a new appointment to the Supreme Court. Again, we want to think about, before we get into the questions of sort of who's on the court and how they make their judgments, what those judgments really are and where they come from. And when we think about these judgments, the first thing to think about is that these court cases generally start small. Just like this bill on Capitol Hill, you may remember this from our discussion of Congress, they have a really long way to travel. They have a long journey from their origination, most of them, all the way to the Supreme Court. And in fact, this is because most Supreme Court cases actually begin their lives as state-level court cases. And so to think about this distinction, think about which kinds of cases come from the state jurisdiction, which come from original federal jurisdiction, I think it's important to think about different types of disputes and just kind of different branches of the law. Those of you who are interested in law school are probably experts in this already, but the first branch of law, essentially, we can think about is criminal law. That is, the kinds of cases that involve violation of laws protecting safety, health, and moral standards. So, anything in your, Special Victims Unit kind of TV show or something is usually criminal law. When we think about civil law, this is a separate sort of category of law. And again, we can think back to the Bill of Rights to think about the differences in these sorts of systems, right? The Sixth and Seventh Amendments. Civil law, we've got disputes between citizens, usually where there's money involved. So we think about lawsuits, but also contracts and other sorts of disputes that aren't criminal in nature. But there's a third type of law that we want to think about, that is public law. And that is essentially law that involves essentially either individuals' rights being violated, including sort of constitutional protections of citizens' rights, and then also something that has to do with the powers of government. So for example, if government is having some sort of negative impact on a citizen, or if governments are in contention with one another, these are the kinds of things that sort of earn the distinction of public law from the get-go. So when we think about this distinction, the first, the best way I think to understand it is to give you an example. And what I'd like to do is just sort of tell you a story in the rest of this module video. As we go through, I think you're going to see that a lot of important concepts related to the Supreme Court, related to this question of public law and of civil law, will become clear to you. And so in 1983, going all the way back to the 80s, there's this guy, Matthew Fraser. You can see him here on the slide. And essentially, Matthew made a speech in front of his class in support of a student body vice presidential candidate. This was, of course, in high schools all across America, we have these student body elections, and they're usually these kinds of silly popularity contests. And essentially, in this case, this guy, Matthew Fraser, got up and gave a speech in support of his friend. And he used in that speech all these clever double entendres. Okay, double entendres. Now, if you're not familiar with what that term means, I can't really give you any examples, because that would essentially mean that if I were to give you some of those, you might be thinking that I'm trying to tell you something dirty, essentially. And that's the thing about double entendres. They sound like they're using words, essentially, that on their own, in their plain meaning, don't have any sort of vulgarity to them. But these double entendres are sort of clever substitutes for vulgarities. And if you're in the know, if you're able to read into the words, then you're aware that essentially these words are intended to convey vulgar meaning. And so in this case, you can read the text of Matthew's speech. Go Google it if you're interested. You can read about all of the different, sort of characteristics, let's say, that he ascribed to the student body candidate, and how this person was going to do all of these things. And of course, he was referring to, in this double entendre way, of the candidate's sort of ability to essentially be good at sex, right? So this was the double entendre that Matthew was doing. It was essentially a series of puns that were all just sort of sex jokes. And so the school board suspended Matthew for 3 days because of this speech. They called it vulgar and offensive. And of course, if you can imagine, if you're Matthew, you might say, with your tongue firmly in cheek, but I didn't say any swear words. I didn't say anything vulgar, right? I was just talking about my friend, and I wasn't using any sort of sexual language. Of course, it was a double entendre, so this was not a clear-cut case. And so in addition to suspending Matthew, the school board also banned him from speaking at graduation, which is an important point considering that he was actually the salutatorian of his class. So in addition to making double entendres, he was quite a smart person. And he was banned from taking part in the school's student election. So for the remainder of the election, he was unable to participate whatsoever. So you can imagine that Matthew was probably pretty upset. And I'm sure that you would be too if you were to make this kind of clever speech and then be shut down, right? Think to yourself, what is the issue at stake here, right? Are these not First Amendment freedoms that are staunchly protected by courts over the decades in American history? So, the issue at stake here certainly is this idea of freedom of speech. And the question before courts is, does the school board have the authority to suspend Matthew and prohibit him from speaking on the basis of this so-called vulgar language? And so essentially what happened was in '83, Matthew and this group called the American Civil Liberties Union, or ACLU, which is sort of a defender of free speech rights and all sorts of other kinds of rights and liberties in the United States, partnered together to file a public lawsuit, so an original jurisdiction of public law, because it's a violation of rights, against the school district claiming this violation. And so Matthew essentially sues the school. And he does that on the basis of 42 U.S. Code Section 1983, which says any person depriving any rights, privileges, or immunities secured by the Constitution shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, which essentially means if somebody violates your constitutional rights, you then have the ability to sue the crap out of them. So again, we are a litigious society. We are a society where lawsuits are commonplace. And part of that is that it is secured in essentially the statute, the code of laws of the United States, that if these violations occur, you are eligible for restitution. And so this is an important sort of point here is that, again, when we think about these violations of rights, part of what we're talking about is lawsuits that are designed to get money back for damages. And so because of the fact that this is public law, as you can read about in the textbook, Matthew's case is heard first in the federal court system. So it bypasses the state courts the way that, unlike the way that 99% of these different court cases originate. And that is, again, because Matthew's lawyers are specifically invoking the First Amendment as the basis for essentially this need for restitution. And so anytime we have these matters of constitutional law as being the primary sort of complaint in a lawsuit like this does become a federal issue. And so the federal court system, of course, is very different than the state court system. I want to make that clear. We've got state courts that exist in Maryland, for example, that, we've got this whole state system where, you've got these different courthouses all around the state, sort of building up all the way to a state court of appeals and eventually the Supreme Court of the state of Maryland. We've got that state sort of thing. We've got 50 of those all across the country. But the federal court system essentially is over all of those things and, again, helps to resolve these disputes that deal with public law, among other topics. And so the original jurisdiction of the federal court system, again, is federal laws, treaties, and matters of constitutional law. Instead of beginning in some sort of trial court in the state, in this case, we sort of circumvented that whole system, which is, of course, where most of the courts are in the United States, and we're now already into that federal system. And so, again, I just want to be clear, every state has its own trial courts, appellate courts, and a state Supreme Court. There was no state involvement here at the get-go, simply because it's a matter of public law. And in terms of where it began, then, Matthew's route is actually beginning in the smallest subunit, or essentially the least important subunit of the federal courts, the U.S. District Courts. And so these courts are located all around the United States. You may have seen district court buildings in various cities that you visited in America. You might see some of these edifices around and think, oh, that's interesting. It's federal court. What is that, and why is it in this city, right? Essentially, these are located all around, and they hear cases of public law, original federal jurisdiction, and other kinds of cases. Of course, we have one of those in Baltimore. Actually, if you drive down, near 83, you'll be able to see that. that courthouse. But other states have more, and part of that is because of geographic sort of distribution. So Pennsylvania, for example, has 3 of these district courts. West Virginia has 2 of them, actually, because there's a huge mountain range that splits the state in half. So even though it's a relatively less populous state, because of geographical considerations, they essentially have these 2 district courts. So essentially, this is where we're talking about, where Matthew's case begins. We have this federal system and the state system that are sort of separate here, but both leading eventually, potentially, to the Supreme Court of the United States. In this case, the original jurisdiction is with the U.S. District Court, in this case, in the state of Washington. And then, of course, as we might imagine, it moves up towards the U.S. Court of Appeals and eventually to the Supreme Court. These are sort of separate systems, but neither are unimportant, essentially, in creating the agenda of the Supreme Court. So, a ruling. Right, Matthew's case eventually gets heard by the Western District Court of the state of Washington. And so there, the case is ruled upon in favor of Matthew. So if you imagine you're a friend of Matthew's, you are supportive of his right to free speech with his clever double entendres. In this case, Matthew gets this ruling. The court holds that the school's sanctions violated the First Amendment. Okay, there you go. There's the first point that we need to make clear here, right? It's a violation of the First Amendment. That seems pretty clear. The school's disruptive conduct rule was unconstitutionally vague and overbroad. That's interesting, because essentially the school suspends Matthew on the basis of this code of conduct student handbook. You probably had one like that in your own high school. And so they said essentially this was vague. Essentially the rule that allowed them to suspend him on the basis of this speech did not clarify what vulgarity was. And also they mentioned that the removal of the respondent's name from the graduation speakers list, essentially kicking him out of graduation, even though he was a salutatorian. They said this violated the due process clause of the 14th Amendment because he hadn't had his trial yet, and they essentially further doubled down on punishing him. And so all kinds of different violations from the school board in terms of trampling all over various parts of the Constitution of the United States. So if you're Matthew, I'm sure that you're ecstatic at this point, thinking to yourself, wow, I might actually have a chance to win. But of course, as we know, the story's not over, right? The school board's lawyers next appealed their decision to the next highest court in that system that we just took a look at, right? So here, they appealed from the district courts to the U.S. Court of Appeals. That's why it's called the Court of Appeals. If you don't like the decision that the district court has rendered, you could potentially appeal that to the next highest court, which is this appeals system. And so an appeal can be filed if you believe as a defendant that you still have a case. Around 20% of federal cases end up in that sort of category where they get appealed. And essentially they'll go to that next level, and the Federal Court of Appeals will make another ruling, essentially whether to affirm that lower court's decision or to overturn it. And so, of course, these courts, this is the next highest sort of level, and so they're located in a few major cities across the U.S. and cover these large regions here. So here we've got, I think, a really nice map here that shows the different jurisdictions. In these little dashed lines, which you may or may not be able to see depending on the size of the device you're looking at, these little tiny dash lines here split different states into the district courts, right? So Maryland is one whole state because we only have one. We can see here Pennsylvania has the western, middle, and eastern. And then within that, we've also got these different colored boundaries, which are describing the U.S. district courts in the U.S. district court system. As you can look around, right, essentially some of these courts cover an enormous amount of territory. So, for example, the Ninth District Court is an incredibly important district. Essentially, the Court of Appeals, right, the circuit, I'm sorry for misspeaking there, the circuit, essentially the Ninth Circuit is huge, right? It covers California and its 4 district courts. It covers Washington and its 2 district courts, Oregon. I mean, this is an enormous, think how many millions of people fall under this jurisdiction of the Ninth Court of Appeals. This one similarly is really large, right? Virginia and Maryland, right, the 4th. You also notice that there's a federal Court of Appeals and a DC Court of Appeals, which are not pictured here. But essentially, if we look through all of these, we've got a number of different very important, powerful courts, which are the appellate courts or the courts of appeal for these various circuits, these geographical sort of places. And you can also see, interestingly, that there's a few sort of weird boundaries here, like where Puerto Rico is associated with the first here. So if you're, if you have some sort of dispute that gets appealed from an original court of federal jurisdiction to the Court of Appeals for the First Circuit from Puerto Rico, you're going to be taking a flight right up here to Massachusetts. The U.S. Virgin Islands, for example, I believe they're part of the third, yeah, based on that color. And then, of course, some of these other minor territories and states outside of the lower 48 are also part of the ninth. So, really, a very interesting map here in terms of the relative power and decision making authority of these different circuit courts. And so, in Matthew's case, of course, he's here in the original district here. The district court was in the western side of Washington here. Of course, he's in the Ninth Court of Appeals. And so the Ninth Circuit Court of Appeals upholds the prior ruling in favor of Matthew. So that's the next step is actually Matthew then wins again, basically, where they say here, the Ninth Circuit Court rules that the respondent's speech was indistinguishable from the protest armband in Tinker versus Des Moines Independent Community School District. Interesting, whatever that is. And of course, maybe some of you have heard of this case before, Tinker case, the armband protest case in Tinker versus Des Moines. But it's very interesting to see that in Matthew's case, which is a very different case dealing with vulgarity and these double entendres, these sort of tongue-in-cheek sex jokes that he makes at a high school election, right? That's very different, perhaps, than this case, which you may know something about, right? This is an earlier case from 1969 in which these students wanted to protest the Vietnam War and they wore black armbands on their clothing, essentially, to school as a protest. The principal essentially said, you can't do that. That's a form of political speech that's disruptive to the learning environment. And the students did the same thing, essentially, that Matthew did. They thought of that section of the U.S. Code that says you can sue on the basis of a violation of somebody's constitutional rights. That goes all the way up to the Supreme Court. And essentially, in this very important landmark case for First Amendment freedoms, the Supreme Court rules that students wearing a political symbol in protest is protected speech due to the fact that political speech is such an important sort of enshrined part of the First Amendment. And so essentially these judges in the Ninth Circuit looked at that 1969 case as a precedent to help understand how they might consider Matthew's specific case. And so they said, okay, well, let's think about cases that existed when we're making the ruling in the 1980s that have a precedent and that have something to do with student speech. And so they looked back to that case and they said, okay, the Supreme Court at that time gave us this roadmap for understanding Matthew's case. It's a precedent case. They looked at it, and what they said essentially was that the facts of the current case, Matthew's case, are not that different from the facts of this case, given that this is a student who's making some sort of speech, right? And so they said that these things are indistinguishable, in fact, which, again, going back to the slide, respondent speech was indistinguishable from the protest armband. And so essentially, in this Tinker versus Des Moines ruling back in 1969, this may have helped the circuit court come to its conclusion, where they said, in that case, the Supreme Court did, schools must be able to show that their action was caused by something more than a mere desire to avoid discomfort and unpleasantness. Okay, so if we think about this is actually in the majority opinion in Tinker versus Des Moines. This is why precedent is so powerful and important. These words matter in directing later lower courts in making certain rulings. Essentially, the judges read this and they said, okay, this is what the Supreme Court generally thinks about this issue or has in the past. Schools have to show that their action was caused by something more than a desire to avoid unpleasantness. And so suspending Matthew for vulgarities, well, that seems a little bit like all they're trying to do is avoid discomfort and unpleasantness, right? That seems like it matches this definition. However, Tinker versus Des Moines indicates that schools can forbid conduct that materially and substantially interferes with the requirements of appropriate discipline. So essentially, if students are way out of line and are essentially becoming too disruptive, it is possible to forbid conduct and to essentially suspend students for doing stuff that's just completely ruining the classroom environment, right? So there's a difference here. You can't prevent stuff if you just don't like it because it's unpleasant, but you can stop stuff that interferes with essentially the mission of the school. And so, right, Matthew's 2-0, right? He's won at the district court, and now he's won at the circuit court, the Court of Appeals in the Ninth Circuit in Washington. He's won twice, right? So case closed. Well, the school board again wasn't satisfied, and so what they were able to do in this case was they were able to file what's called a writ of cert, also known as a writ of certiorari, with the Supreme Court. And so this is where, again, the school board, being 0-2, they lost at the district level and they lost at this appellate level, are able to now ask the Supreme Court to revisit this ruling of the circuit court. And so the writ goes all the way up to the Supreme Court's clerk's offices, and it's reviewed by the Supreme Court, right? And they make a ruling on it in 7 days, or your money back, right? Well, of course, anytime I ask you a question with this kind of ending, right, that that's probably not going to be the case. And of course, there's a sort of not so fast moment here, and that is the fact that the Supreme Court gets a tremendous number of appeals every year, and they get to be very choosy in terms of which cases they take. And so the first barrier, essentially, to cases coming before the Supreme Court is the clerk's office. Okay, so every Supreme Court justice has people that work for them that are known as clerks. Essentially, this is a job description. This is a very, very, very good job. This is a job that thousands and thousands of lawyers across the country want desperately to have, because this could mean that maybe one day you yourself would get to be a federal judge somewhere, and perhaps maybe even one day rise to the level of the Supreme Court. Every Supreme Court justice has these clerks, and they do a tremendous amount of work, as you might imagine. They work very, very hard to process this mountain of information, essentially, this mountain of appeals that comes before the Supreme Court every year. And so what they essentially do is they read all of these cases, they read all of the facts of the cases, they think about what their specific justice, who they're working for, whoever it might be, has told them about their specific sort of interests, their specific sort of guiding principles. And then they write these memos to each other, and they circulate the memos, they read them all, they pass them back and forth. And eventually, they inform their justices about specific cases that they think are particularly salient for a variety of reasons. And eventually, the clerks and eventually the justices actually will meet, and essentially they will have a secret vote. And if 4 clerks, and by virtue of the fact they did most of the work, their justices, or 4 justices, and by virtue of the fact they did most of the work, their clerks are convinced they should hear a case, then it will go on to the Supreme Court after that secret vote by the justices. And so this is a huge check, because even if one set of clerks and eventually their justice thinks that a case is really, really important to hear, unless they can get 4 out of the 9 to agree, then it's just not going to happen. So it's not a majority, but it's enough. It's enough justices that it's a pretty high hurdle. And so we can see here, this is I think a nice little description from the textbook of the decision-making process, where it starts as a petition. So we saw that in Matthew's case, this was the school board petitioning for that second time from the appellate level to the Supreme Court level. Eventually, that petition might make its way into the certiorari pool, right? The pool of the essentially the cases that the clerks would actually consider, where they're passing memos back to each other. Eventually, it could make it on the discuss list, essentially, where then the justices are actually going to talk about it. It might go to conference. It might get then written up into briefs, where there actually be the lawyers for various sides will then actually write their formal written argument as to why they are right. And they might hear as well these amicus curiae briefs, or amici briefs. These amicus curiae briefs are also, as we'll talk about in a moment, additional written arguments from sort of interested parties that are third parties who aren't actually the lawyers on either side of the case. So the Supreme Court, throughout this whole process, is essentially gathering a tremendous amount of information, but they're also, and the key takeaway here is, they're winnowing down the set of potential cases through this first half of the process. Getting a case actually written up into briefs is very rare, right? Actually making it onto the discuss list and into the conference where it becomes discussed, right? This is a very small percentage of the cases that come through the petition pool. Finally, there's oral argument, which certainly we're going to see some examples in the module of some oral arguments of Supreme Court cases, where the lawyers actually get to have their day in court. They get to actually petition the court verbally and get sort of grilled by the justices when they ask them all kinds of hypotheticals and to do all kinds of stuff to prove their case. Finally, it goes back in a conference where the justices talk about the case again, and then they will have a vote essentially on the ruling of the case, the outcome of the case, and then the justices will do the difficult work of writing up their case into opinions, or the majority opinion, and dissenting opinions, and potentially concurring opinions as well, if some specific justices want to sort of throw in additional argumentation. And so all the way from this petition level all the way through to the opinion and dissent level, that's an incredibly difficult process for a single case to make it all the way through, and it's one of the reasons again why there's only so many Supreme Court rulings every year, despite the fact that there are thousands upon thousands of petitions every year. So in Matthew's case, I remember Matthew's speech in front of his high school was in 1983. And so by this time, when the school board appeals Matthew's ruling a second time, the Supreme Court, it's 1985. So in that case, again, if we go back to that map here, this petition list, there was about 5,000 writs of cert that year that came to the Supreme Court. Again, only about 1% of those writs actually get placed on the court schedule. And lo and behold, as you might imagine, because I'm telling you this story, Matthews turns out to be one of those cases that at least 4 justices agreed in secret should be heard. And so it goes on the court schedule, and it gets written up into these briefs, and eventually goes on the calendar for a date where it will be argued orally. And so the question we need to think about is, in addition to some of this stuff I have at the bottom of the slide about some of the procedural sort of definitions for why take a case, I kind of wonder, maybe you can pause the slide and ask yourself, why would the Supreme Court be interested in taking this case? Why would they do that, right? Beyond these things, right? Of course, we know that it needs to be ready for litigation, so it can't be about some sort of thing that's happening in the future because there's uncertainty there. It has to be, the parties must have standing, which means that essentially that people's legal sort of status can't have changed over time since the actual thing happened, and of course the case must not be moot, which essentially would mean that the problem essentially has been resolved through other means. Despite regardless of these things, I guess the question is why this case and not one of the 5,000 other cases. And so I think that the answer to that question is a much more interesting one because it becomes much more political. Because the Supreme Court obviously is operating and they're thinking carefully about how their rulings might have political ramifications for the rest of the country. Because again, we talked about this earlier court decision, right? This Tinker versus Des Moines decision. That became the precedent that had an influence on a later case, which meant that an appellate court was able to think about the words that were written in that majority opinion, right? It's the majority opinion specifically in previous cases that instruct later courts how to act. This is an incredible power, right? This is a power to essentially set the ground rules of the interpretation of the law for the rest of the courts. And so these justices are thinking very carefully about taking specific cases in instances where maybe they want to amend to some extent the way that the law is being practiced in other courts. They want to provide essentially a declaration and say, no, look, we need to overturn the way that we're thinking about this kind of issue in America. We need to fundamentally change the interpretation of the Constitution on this thing. This might be a sweeping landmark ruling that has huge ramifications for all kinds of stuff. Or they could say, the existing, cases that we've heard that clarify for people what's going on with this issue, they're not specific enough. And we need to make sure that there's a distinction here between this kind of a situation and another kind of situation. And so we want to take a case that helps us really differentiate between two sort of sets of facts so that we actually create, again, this is essentially upholding the existing sort of interpretation of the Constitution, but it's providing now much more detail about one specific circumstance where maybe we want courts to interpret it this way and not that way. And then a third example might be maybe they just want to make a statement, right? Maybe they want to explain to the American public how something might work. And in reaffirming a certain principle, they might take a case so that they can say, look, the law here is clear. You cannot do this or you must do that. And so those are at least a few of the reasons, again, very political reasons why Supreme Court might take specific cases, either to change things, or the way that interpretations happen, to clarify, or to reinforce an existing legal principle. And you can see now why it's called the Supreme Court, right? It's an incredibly important power in that sense to interpret the way that the law is practiced. So again, just to review, right, there's very careful discretion here as well, because the other thing that we want to think about is this thing that Justice, I believe Felix Frankfurter was the first to call it, the political thicket. And this is essentially the idea that the Supreme Court rests on public support, public confidence. And so if we think about the power of the Supreme Court, it's really in creating these rulings and having other people essentially trust that they've made a good decision and following the letter of that law, right? Again, a Supreme Court ruling might affect the interested parties in that specific case, but at the end of the day, it's just a piece of paper. They rely on other people to comply with that judgment in order for it to have any power or meaning in real life. And so they need support. They need people to think that the Supreme Court is not in some way illegitimate or biased or tarnished, right? They want people to think the Supreme Court is a fair and, powerful and sort of righteous upholder of the law. And so one thing is that Supreme Court cases, they might be, very worried about taking certain cases that might make them look more political, right? More biased, essentially, in terms of a left-leaning or a right-leaning sort of flavor of jurisprudence than if they didn't, right? So in many cases, like we've seen, for example, up until the present day, the Supreme Court has been extremely reticent to take a lot of cases having to deal with reproductive rights because they see that as being a very scary thing where they would essentially spark protests. People would be mad at them. People would stop thinking that they're doing a good job, regardless of which way they would rule. So these like hot button issues, the Supreme Court might also say, we want to put that aside because we want to retain our sense of legitimacy and feel like we're sort of rising above the fray of partisan sort of back and forth. Right. So again, this is a very complicated and difficult process for the Supreme Court as they try to spell out the way the law should work, but also attempt to at least, on the surface of it, appear nonpartisan. Now, in Matthew's case, right, after it goes on this discuss list, after there's this secret vote and it gets through conference, the case gets written into these briefs. Again, I was referring earlier to the fact that the school lawyers write what's called a petitioner's brief, where they're petitioning the Supreme Court to reconsider the appellate court's decision, the circuit court, right, that Ninth Circuit. And then Matthew's lawyers then get to write a respondent's brief in which they say, look, no, like, we believe that this was correctly argued the first time. And then again, like the ACLU and other groups also were able to write amicus curiae briefs, which are essentially interested parties who might have a stake in this, say. So you could imagine that other groups that have some stake in issues of student speech might want to have their say and write up some of these briefs, hire some lawyers to attempt to put some pressure on the Supreme Court to make certain rulings. Now, if you think about it, right, like if the ACLU is writing this, we know how they're going to argue, right? If I don't know if this kind of body exists, but like the board of concerned, parents who don't want vulgarity in schools, if they're writing an amicus brief to the Supreme Court, you know how they're going to, interpret this. They're going to say that Matthew's speech was unacceptable. Why would the Supreme Court want these in the first place? Well, I think the point here is that amicus briefs are very helpful for the court, even though they know that many of these opinions are quote unquote biased, right? I mean, the opinions that they're receiving are opinions that push an argument in certain directions. And having a diversity of those arguments helps them to see all of the different angles, right? And so reading those briefs actually can be very helpful for the justices as they prepare for oral arguments, where they might start asking these lawyers to explain what might happen in a different hypothetical scenario, or what might happen if we were to very slightly alter the facts of this case. Again, this oral argument is quite the grilling if you take a look at those oral arguments that I've included in the module. And so again, going back to oral argument, they get read. The lawyers appear before these 9 justices. It's a very, very stressful situation, certainly for these lawyers, and you have to be very, very cool under pressure because the lawyers, again, they get absolutely grilled in these things. And at the end of oral arguments, the justices return to their conference to discuss this matter in absolute secrecy. And eventually they will reach a verdict, and the various justices will have fallen on one or the other side of the issue. And essentially, the judge that gets selected to write the majority opinion then creates this written document that becomes the precedent, for later court cases. So this opinion is super important, right? We talk about this idea, the doctrine of stare decisis, the idea that standing court decisions are decisive in later court decisions. And so later judges can read these. This is why lawyers need to know a lot of stuff, right? Why you have to study very hard when you're a lawyer, because you have to know all of this precedent in order to have convincing arguments. And again, which justice writes the opinion also matters a lot, right? Some justices write very terse, very limited kinds of opinions. Other justices write in more flowery language that's a little bit more circular. It really depends a lot simply about who the justice is, because they all have sort of slightly different styles. But again, the opinions get written up, and finally, wait, not finally yet, right? We don't get to talk about Matthew's verdict yet without thinking about the dissenting opinion as well. And so generally, the senior ranking justice of the minority opinion, basically this minority of the 9, so either 4 or 3 or 2 or 1, will write a dissenting opinion, essentially in which they argue why the majority got it wrong, basically. And you might be wondering to yourself, if this isn't going to become part of precedent, or the sort of doctrine of stare decisis means that the majority opinion is what becomes this blueprint for future courts, why do this? Right? Is it just because you're upset and you want to vent a little bit, get it out, right? Well, the point here is that dissenting opinions help judges think about what might happen next time, right? That there's a case that has similar criteria, and also importantly, it might help lawyers make arguments in the future when they're trying to argue their specific cases. So these dissenting opinions might say, look, hey, this may have not fallen the way that I wanted it this time, but I still think that there's like a crack here, where if somebody wedges an argument enough into this crack, then it might break open, and you might end up having a new ruling in the future on a different, separate case that overturns this precedent. And so it's essentially a roadmap, or a way that these justices might see the opposite argument eventually becoming convincing. So these can also be very important documents, as we've seen, in some examples when we talked about civil rights and liberties. So did Matthew win? Well, this was a 7-2 decision. It was handed down by Chief Justice Warren Burger. This majority opinion, eventually the verdict was that, again, Matthew's 2-0 here, right? Eventually the opinion is that Matthew did not win in this case. And so here's a big chunk of this. You can read along with this. But essentially, what this Supreme Court case argued is that the First Amendment did not prevent the school district from disciplining the respondent. And they said Tinker versus Des Moines distinguished. So again, this is the case of a Supreme Court decision where they're trying to say, look, the precedent that existed was Tinker versus Des Moines. This is a slightly separate sort of issue. Right? We want to make sure that later cases that deal with vulgarity are not ruled on the basis of the Tinker versus Des Moines case. We want them to think about this other set of facts in order to help further clarify and distinguish where the limits of free speech in schools for students might be. And so they say, under the First Amendment, the use of an offensive form of expression may not be prohibited to adults making what the speaker considers a political point. So essentially, if you're an adult, then you can say whatever you want, even if it's vulgar, in the realm of politics. So this is one of the reasons why, right, people aren't suing each other all the time in politics, because they might have called them a bad name in a debate or something, right? However, you need to think about the fact that this is a different case than adults making political expressions. It does not follow, writes the court, that the same latitude must be permitted to children in a public school. Okay, so again, Matthew is not of legal age at the time that he makes this case, or makes this speech. It does not follow the same latitude must be permitted to children. And they write here, it's a highly appropriate function of public school education to prohibit the use of vulgar and offensive terms in public discourse. Nothing in the Constitution prohibits the states from insisting that certain modes of expression are inappropriate and subject to sanctions. The inculcation of these values is truly the work of the school, which I find to be a very interesting expression. This idea that it's not just about First Amendment liberties here. It's actually about the idea that the school is trying to teach something beyond, algebra. It's trying to teach values. And so again, I find this to be a very, interesting and, potentially controversial kind of Supreme Court case, where they essentially say, look, children don't get these same liberties to the same extent, right? There's a certain latitude that can be restricted by agents of the state, or essentially by public school officials. And that is because part of what is important about public schooling is inculcating certain kinds of values. So again, huge decision, and one, again, that goes against Matthew and his vulgar speech. And means that he will not be able to earn restitution. He would not have the right to speaker graduation. He would not, again, this is many years later, so by this time he's 22 years old. But he would not essentially be able to win this case and get the restitution that he thought he deserves. And so again, Matthew won twice, one in the district court, one in the circuit court, and then lost at the Supreme Court. And so could Matthew appeal? Well, the Supreme Court is supreme, which is another aspect of this. There is no higher court. There is no more further appeal. You can't go back to the Supreme Court and say, can I get a do-over? Once they rule, that ruling is final and absolute. That is that's why the Supreme Court is thought of as the highest court in the land. You cannot appeal to another level. And so even though Matthew went 2-1, winning at those lower levels, once the Supreme Court rules, the ruling is final. Wow. Tough for Matthew, right? Pretty tough. But again, that's the way that system is constructed in order to give the Supreme Court that last say. And it's, again, one of the reasons why the individuals who are on the Supreme Court and who they are matters tremendously, because that balance, essentially, of justices and their different interpretations of the Constitution, that's, again, the final say in terms of that constitutional doctrine that will become the law of the land for the rest of Americans. However, one thing that Matthew can rest easy knowing is that his case is still important, even after it was concluded, because it became precedent. Again, stare decisis. It became this clear distinction from the Tinker versus Des Moines armband case that future courts could use as a sort of blueprint for understanding how to rule on decisions related to students and vulgar speech. And so one example of this, you may have heard of this one before. In 2002, a similar case came before the Supreme Court. This was a case in which a student in Alaska held up a sign at a public school reading "Bong Hits for Jesus" as the president drove by in a motorcade. And so the principal took the sign away, suspended Joseph for a week. And I love this detail. They increased the suspension to 10 days when Joseph came to the principal and quoted Thomas Jefferson during his interview and said, hey, I've got these rights to free speech. You're infringing on my rights. Don't take my rights away. I can hold up signs that say "Bong Hits for Jesus" however much I want because it's a free country. The principal disagreed, and the case made its way all the way to the Supreme Court. And amazingly, this narrow 5-4 majority opinion cited Bethel School District versus Matthew Frazier. That is the 1980, 5-6 court case that we just talked about. And in this case, they said, look, this is not like the protest armband. This is not the Tinker rule. This is actually, this case, the Bong Hits for Jesus case, is in fact much more like Bethel School District versus Frazier. And as a result, Joseph also lost his case. So maybe Matthew can't sleep as easily, can't rest as easily, knowing that actually his precedent is being used in later years actually to prevent free speech among other public school children who are engaging in different kinds of supposedly vulgar speech. So the whole point, the thing I want to really drive home here is this idea that Supreme Court precedent is an incredibly powerful tool. However, again, when we think back to this idea of who takes cases and why, we also want to think about the fact that creating these precedents also can be a double-edged sword, because the essentially public opinion of the Supreme Court is the kryptonite of the Supreme Court. And so when the Supreme Court rules on issues that are incredibly divisive and incredibly likely to spur certain kinds of protests, like we think back to, in 2010, for example, right, in, a very important ruling of Citizens United versus the United States. The Citizens United case is incredibly important and one that has generated a tremendous amount of public backlash, in which we saw Supreme Court perceptions in the public, according to surveys, essentially dropped after that case. And so again, we want to think very carefully in the aftermath of both Matthew's case and Joseph's case, and some other cases that we'll be learning about in additional module videos, just really about the degree to which the Supreme Court is an extremely powerful institution, one that the Constitution says relatively little about, but also an institution that is quite vulnerable, and vulnerable specifically to the public's perception that it is becoming particularly partisan and particularly biased in its rulings. And so obviously there's a lot to talk about there, a lot about the future of the Supreme Court in America right now as we think about sort of the direction of the court for the years to come. This intensely partisan battle that is designed essentially to supplement an institution that is supposed to be, at least on paper, nonpartisan. So I hope that you enjoyed the story of Matthew Frazier. I look forward to your reactions to it, and I wish you a wonderful week.